Molweni Afsheni Tobelandaka. I say you know, today we are back with CPR3701 1033 2024. You know that when it's time for you must know that most of the exams will come from this tutorial letter. So it's very much important that you answer this tutorial letter. It's a semester 2 2024, and then you must. However, with me, we are going to answer all the questions so that when you get into the examination, it will be fish and chips. Yeah, fish and chips. Okay. Okay, now we are starting. We are on this. You must even know this. Please note the following in respect of assignment number 3. The questions posed in this assignment represent the format of questions which you will be expected to answer in the examination. The assignment need not to be submitted for marking or anything. So now let's deal with this one. If we deal with this one, you know what the examination will be like. In Vermeulen, a town in the Northern Cape, South Africa, two rival gangs, the hard dying and the live to die, are involved in long-standing territorial struggle. A group from the live to die gang attacks another from the hard dying at Strasso Street, Vermeulen. The members of the live to die gang attack those of the hard dying with an assortment of weapons. A member of the hard dying is subsequently found dead by the police at the scene of the altercation. So we are starting now. The police arrive at the scene in two vehicles. Upon seeing the police, the group of wearing gang members disperses in different directions. Both police vehicles give chase in two different directions. During the ensuing chase, the drivers of the first police vehicle manage to isolate two suspects, namely B and C. Sergeant Trigger AP gets out of the vehicle and runs after the suspect on foot. Sergeant Trigger AP orders the suspects to stop, but they continue running. Seeing that they will not be able to catch the suspects, he first orders them to stop firing his weapon in the air. When the suspect fails to heed his request, he fires directly at B, hitting him on the leg. B is then arrested by the police. In terms of Section 49, subsection 2 of the Criminal Procedure Act 51 of 1997, an arrester may be reasonable and proportionally forced to arrest a suspect who resists attempts to arrest him or her. Critically evaluate whether Trigger's happy conduct conforms with the requirements for the use of force when effecting arrest as enunciated in the CPA. Don't forget that when you join me here, it will be peanut butter because all the questions of the CPR will be here, and then you'll be able to see the full question paper. I told you that we are answering the full tutorial letter because this tutorial letter is very, very crucial in the examination. So watching this tutorial, this video, and joining here on the current assignment, 99 Rand, then you will see all the videos. Current assignments, 99 Rand, then you will see this video of a CPR. Resisting an arrest. So I'm resisting an arrest. We call it a resisting arrest. Use of a force to overcome resistance against or fleeing from attempt to arrest. Justified homicide by an arrester who is by statute authorized to arrest or to assist with an arrest. This is people who are authorized. It's authorized by section. Strict requirements are laid down before an arrester can invoke a defense of justifiable homicide set out in Section 49. According to the pre-revised section, whether a person concerned was to be arrested for an offense referred to Schedule 1 or was arrested on the ground that he was reasonably suspected of having committed such offense, and the person authorized under this act to arrest could not arrest him or prevent him from feeling by other means than by killing him, the killing should have been deemed to be justified homicide. Then it was amendment. The new Section 49 no longer distinguished between offenses. This essentially means that to kill a suspect during the arrest process is not allowed unless lives are endangered. The section is very important and should be studied thoroughly. What should be borne in mind is that the force used in either overcoming the resistance of an arrestee, preventing his or her escape, must be reasonable, necessary, and proportionally in the circumstances to overcome the resistance or to prevent the suspect from running away, right? The use of dogs as instrument of force should comply with the requirements as set out in Section 49, depending on how much force was used, right? Then there were some cases that they decided in Botswana, then they decided that it was held that where an officer knowing that his dog is aggressive and is likely to injure a suspect, and where colleagues were available to assist him, the risk of injury by setting police dogs on the suspect far exceeding the risk of injury from physical overpowering by the number of police officers, the police therefore did not employ the method with the least. Then this is this one. I remember in 2023, first semester, people have written about it. They selected exploring the application of the force during arrest in relation to Section 49 of the Criminal Procedure Act. So we were writing about this issue. And people written about it, and it was. Then in that one, we enjoyed. I remember writing about it. I enjoyed this one. Research problems. I was enjoying here the use of force, and then there were some questions that I used about. That I had written, legal convictions, then talk about the arrest, Bill of Rights and addressing brutality, human rights violation, and then guideline. Guys, I wasn't enjoying. So I'm showing that I do have this one of the use of a force. I have written about it, so I have them. I know everything about it. However, I will not, for Section 49, subsection 3 outlined that when necessary in order to effect an arrest, a police official may use only such a force as is proportionate and reasonable under the circumstances, while taking into account the age, gender, and health of an accused, as well as other relevant circumstances. These parameters are enforced by Section 48, Section 8, which states that any action or the use of force outside these conditions is strictly prohibited. The goal here is to ensure law enforcement personnel are treating people with respect and dignity while simultaneously upholding their responsibility. That was me. That was me. Guys. Yeah, but you guys, because I don't want to give you it's the same information. So I'm starting that tutorials as I've said, because I've been writing it down. So I just given section 49, like for example, I've written section 49 of the CPA addresses the apprehension of a suspect through application of a physical coercion. To be considered lawful, an arrest must meet certain requirements. The force used must be immediately necessary to protect the arrestee or other from imminent or future harm. There must be a significant risk of harm if the arrest is delayed, and the offense must be serious and involving life-threatening violence. In government, The appellant's son and his friends were spotted by the police driving a stolen vehicle. The authorities pursued with sirens and blue lights activated. But Jay, the driver, did not pull over. Following the fast pursuit, Jay stopped the vehicle and tried to escape on foot. One of the officers chased after him on the foot and yelled at him to halt. The officer discharged a signal shot into a grass incline and once more yelled at him to halt. The police officer was certain he wouldn't catch Jay, so he shot at his legs. The bullet hit his back, causing him to become paralyzed from the waist down. In the case, the court chose to broadly interpret the necessity of reasonableness while analyzing Section 49, subsection 1. To this end, the court concluded that full weight had to be given to the fact that the fugitive was obviously young or unarmed or of slight build and so on, and where applicable, he could have been brought to justice in some other way. And I just concluded by saying trigger conduct conforms with the above requirements. Therefore, he could rely because the person just be shot on the leg, just because of that only. As I've told you guys that I have a people who follow me on the channel who understand that a person must be thanked. You know, I've already posted 211 videos. I'm very happy that I've already posted 211 videos of education. So it means that you can find a lot of videos even previously. You can come here and find a lot of videos that can help you with a study. I hope that I've already posted another videos of a CPR if I've not forgotten, but there are a lot of videos that I've posted. But one of the things that I want to say is that most of the videos now are available here on the joint, so you might not see them. Just come to the current assignment, be on the lookout so that you are not left out. You will enjoy this CPR in the examination because we are going to finish up this question paper, and if we finish up all this tutorial later, it's gonna be fish and chips. Okay, let's go to question number 2 now. It says in terms of section 35 subsection 3D of the Constitution and section 50 of the CPA, an arrestor must be brought before court as soon as reasonable possible. B, who is injured on his leg following the shooting by police during his arrest, is detained at the local police station and made to appear in court on the next day. Sergeant Noisy Kekana recounts that B only suffered a flesh wound and that nothing prevents his attendance to court. B complains to Noisy Kekana that he is unwell and needs medical attendance before properly defending himself. Critically evaluate the lawfulness of Noisy Kekana's conduct in the context of South African as set of above. So we are only basing on the section 335.3 D and then section 50 of the CPA. As you can see, this case deals with the right to be brought before a court within 48 hours. You can see read section 50 of the CPA and section 35.1C and 35.3D of the Constitution. The principle of legality requires that the conduct of law enforcement officials should comply with the norms of the law of procedure. With regard to speedy production, and accused who has been arrested with or without a warrant must be brought to a police station or to a place mentioned in the warrant as soon as possible. If he is not released due to the fact that no charge is laid against him, he may not be held for a period of longer than 48 hours unless he is brought before a lower court as his further custody for purpose of his trial. In order, the 48-hour period is extended by the provision of section 50 of the CPA as amended. This can result in an accused who has been arrested on a Wednesday afternoon to appear on a Monday. Then we come here and check what it says. Then we have 35.D, which says that the Constitution further buttresses the provision of the Criminal Procedure Act in this regard in terms of everyone who must be, which is the same thing that we're reading. And then there were some cases, but that's not important. The important is here where they talk about this one. They said, where the accused cannot appear in a court because of injury or illness, the calculation of the expiry of 48 hours becomes elastic. In other words, the period expires on the first day on which the accused becomes physically fit to attend court proceedings. In the meantime, a medical certificate must be submitted to the court, setting out the physical condition and the whereabouts of the accused. Therefore, in this regard, it means that since the B is still complaining, he must be brought to the hospital, and then they must produce a medical certificate saying that he's still under this care and he's whereabouts. Then when he's fit, then he can go and face the law. They can be brought to the court. Last thing I'm saying, guys, it will be fun when we do this CPR. I'll be posting those videos and you'll be watching, so that the day you write CPR, you'll be much more. You'll be very ready, very ready. Don't worry, everything will be all right. Join me, and then examination will be chips and fish. So next time, guys, when we meet, we'll be meeting when you have joined. Thanks those who will be joined. It will be beneficiary for them. Only 99 Rand will make them to be more vigilant on the examination. Thanks, guys, for watching.